Our moderator for this session is David Reuter. David is a professor here at Northwestern. He's been dean of the law school. He's also been chairman of the SEC. He's currently president of the Corporate Counsel Institute. He's been very active, a leader at Northwestern for many years. Please welcome David Reuter.
Thank you, Henry. It's a pleasure to be here and to be part of addressing this important matter. I am not only a professor here, but I'm one of the Searle Fellows. The Searle Fellows are charged with the oversight of the Searle program, and Henry, we will be doing our work. So, tort reform has been a collateral interest of mine over many years. In preparing for this program, I discovered that in 1986 I served as a reporter for a business roundtable project aimed at advancing tort reform. A copy of that project is in your book, and I was quite interested to see how closely the recommendations at that time are the same as the recommendations for tort reform that are now being advanced. I've also been, over the years, intensely interested in securities law litigation, and that area, too, has, in its fraud context, a great reform interest. And in 1996, I served as chairman of the NASD Arbitration Policy Task Force, in which we were making recommendations for reform of the securities arbitration system run by the NASD, and one of our contentious items was whether or not there should be caps on punitive damages in the securities arbitration system. We indeed made a recommendation that those caps be put into existence, a recommendation which was soundly defeated by public outcry and the SEC. I come to you today bandaged with a result of a small operation that I had, and I'm putting aside any thoughts of lawsuits until I see how my chin heals, but I doubt that I will be in that group anyway. Our panel this afternoon will discuss the impact of caps, looking at both non-economic compensatory damages and punitive damages. I'm going to introduce all of our presenters and commentators now so that we can proceed through our panel with a minimum of delay. Professor Ronald Allen of Northwestern's law faculty is an internationally recognized scholar in the fields of evidence, procedure, and constitutional law. Want to raise your hand so we can all see Ron? Ron deals with facts and will address the questions of how non-economic compensatory damages and damage caps can be addressed factually in a reliable way. Professor Catherine Sharkey of the Columbia Law faculty is a prolific author in torts and other areas. Catherine, thank you. She has addressed punitive damage awards both in her scholarly writing and in testimony at various times. Catherine, if she follows her manuscript, will address the differences and similarities in punitive damages and the non-economic portion of compensatory damages. You've already heard from Ronan Avraham. This afternoon he will address the circumstances in which caps on non-economic damages both decrease and increase litigation expenses. A topic I found to be very interesting, if you're going to follow that manuscript. Our three commentators will react to the three presentations and perhaps give their own views regarding the desirability and effectiveness of caps on non-economic compensatory damages and on punitive damages. I'm pleased to welcome Albert Yoon, one of our brilliant young Northwestern faculty members. Albert. John Vail is Vice President and Senior Litigation Counsel with the Center for Constitutional Litigation and has been actively concerned with the constitutionality of tort reform. John? And finally, with us is Dr. Richard Anderson, who's Chairman and CEO of the Doctors Company. You've already heard from one of that group this morning, and the company is the leading U.S. physician-owned medical malpractice insurance provider. Richard, welcome. So without more, Ron, you will begin in your strict 10 minutes of presentation. Thank you.
Thanks, David. I am honored, pleased, and a little surprised to be standing in front of you today. Honored, obviously, because it's such a distinguished group. I'm really quite astonished by the talent in this room. Pleased, because until today I had no idea that so many of my younger colleagues own coats and ties, and this gives one great, great hope for the future, as I'm sure David would agree. Surprised because I'm not a tort scholar. My research interests are in epistemology, the study of knowledge, both classical questions about justifications of knowledge, but also how the legal system structures and deals with these questions. My work in this area was actually driven by my own interests, not yours. I was puzzled by three different things. I was puzzled by, well, first of all, there's a lot of discussion about torts around here, as you can tell from today and so on, and there's a lot of talk about damages and the facts of damages, and a lot of talk about non-economic compensatories being facts, and I was puzzled by what that might mean. I understand what pain and suffering is, but I didn't understand what the economic measure of that would be, which would be the critical facts. So I was puzzled by that. I was puzzled by the constant refrain when one gets into this literature and the cases and the discussion about jury control over this fact-finding process. And the reason I was puzzled by that is in the first part of my career, I spent a substantial portion of my time dealing with analogous questions, the relationship between judges and juries. And what one finds there is that notwithstanding enormous political opposition in the 19th century, the beginning in the early part of the 19th century, to judicial control over fact-finding, waves of populism swept the country, Jacksonian democracy. This is a tale you probably don't know, but this resulted even in such things as state constitutions being amended to limit the role of trial judges. Trial judges were an elite that had to be controlled and regulated, and the immediate response invariably was for the trial judges, the judges generally, not just the trial judges, to reestablish control over the fact-finding process. So frankly, a priori, I just didn't believe this conventional statement that juries have always had great discretion in deciding these, whatever they might be. And then thirdly, it struck me as weird what I was hearing my younger colleagues in particular talking about caps. Not their view on caps, but they were talking about caps. If there's a problem with non-economic compensatory damages, and if they are facts, it lies in their reliability and the determination of them in a reliable fashion, a point I'll get to in just a second. Caps are not responsive to that question. Caps may take out the extraordinary case, but they don't increase the reliability of fact-finding if, in fact, fact-finding is occurring. So on the basis of these three puzzles, we decided to do what's been a long-term research program into the nature and implications of the legal regulation of non-economic compensatory damages. With respect to the fact of the matter, I think there's an important preliminary point that has to be emphasized. I mean, my general view is that absent explicit authorization from a legislature, and even perhaps with it, resources of one person should not be given to another unless there's a reliable basis for it. In other words, there is a fact in the matter that can be found reliably. Now, where does this come from? There's a lot of talk in the law schools about the Enlightenment and its consequences. That talk tends to focus on the political side of the Enlightenment. There was, in fact, a more important aspect of the Enlightenment, and that was the replacement of dogmatic knowledge with empirical knowledge. Now, how does this map onto the legal system? Rights and obligations are actually parasitic, dependent upon facts, not the other way around. The single most important thing a legal system can do is find facts accurately. Take any claim of a right or obligation, like Mr. Yoon's tie. Didn't know he had one, but now I go over and say, you don't have any ties, give me my tie back. What is he going to do? He's going to search around to find a fact finder to whom he'll present evidence that will establish either a certain day he bought it, was given, or made that tie, and thus he has the right to possess, control, and dispose of that tie. So rights and obligations are actually dependent upon facts. It's the empirical revolution of the Enlightenment, which is actually deeper and more important than the revolution on rights and obligations and the relationship between the citizen and the government. So now think about compensatory, non-economic compensatory damages. What's the fact of the matter? The violation is the infliction, say, of pain. The relevant fact of the matter is its value. Compare a contract. Suppose the statute said to a jury or a judge, if you find a violation of a contract, give as much of Microsoft as you like to the plaintiff. That would be laughable. Yet in the absence of a fact of the matter, of the economic measure of pain and suffering, that's precisely what occurs. So either there is a fact of the matter or there isn't. If there isn't a fact of the matter, then non-economic compensatories are subject to the same arbitrariness analysis as the punitive damage cases, and that's just an easy story to tell. If there is a fact of the matter, they have to be reliably determined. That means what the fact of the matter is has to be identified by somebody, legislature or something, and I'll have a solution here in a second, or a possible solution, and found in a reliable way, like everything else. Otherwise, you slip into this arbitrariness that, as I say, the Enlightenment Revolution was designed in part to eliminate. There are three responses to this argument. One, due process doesn't really demand factual reliability. And we, in the paper, and this is not the paper that's in your materials, this is something I'll get to in just a second, we demonstrate that's false. The single most important attribute of due process adjudication actually is factual reliability. Second, maybe, a page of history is worth a volume of logic, and that a fact meant something to the founders other than what it means to us. So we have another section of the paper showing that's false. And how could it be otherwise? I mean, the founding era was in the aftermath of the Enlightenment. I mean, how could it be otherwise? And then thirdly, and that's where this paper comes in, maybe again, history speaks to the contrary. Maybe it's true. Juries have always been given this question to decide in an unbounded way, and if that's so, well, life's tough. That's what we've always done, and that's what there's no reason to change it now. So we did an empirical study as part of this conceptual program. We looked at every compensatory damage case in the 19th century. I don't have time today to go into the real, the serious statisticians will see what I'm saying here, into the real statistical implications of this, but I want to show you a few things. These dots represent all the cases with compensatory damages in the 19th century. How does this work? I got it backwards. Shows you how sophisticated I am. The blue ones are affirmances. Now look, there are only two and these are, by the way, controlled for $2003. So these take the verdicts during the 19th century and put them into today's dollars. There are no cases affirmed from, this is about $450,000. There are no cases other than these two, and these two are peculiar ones I could describe, if you like. What do you see? Well, first of all, what you see is all these orange dots. You know, the Supreme Court will say things like, judges were reluctant in the 19th century to reverse cases. Well, guess what? They reversed half of them. Half. That conventional belief is just false. Moreover, they'll say things like, well, judges were more reluctant in cases involving non-economic compensatories and punitives to reverse because there's no good measure. When there's a measure and they get it wrong, you can reverse. The rate of reversal is higher in those cases than in cases involving just economic compensatory damages. Now look what's happening here. You can just see, if you imagine medians, what's happening, see these are all reversals of low cases, not just the high cases the courts are reversing. What they're doing is they're squeezing all these cases down towards a median, getting rid of the outliers, radically getting rid of the outliers upward, but of course there's no upward bound, so it's a bit of a statistical anomaly. But even getting rid of the outliers below and compressing cases towards the mean. Now we did all kinds of statistical analysis of this data, and it's very robust. We've disaggregated for cause of action, for time, for all kinds of stuff. So where does this lead? I've only got a minute or two. Do I have, say, 2 minutes?
You have a minute and 16 seconds.
All right. Because you spoke so slowly with your bandage, I'll take a minute and a half. Let's retreat now to the question of what the fact of the matter is. I actually don't know what the fact of the matter is, but one thing you can see from this is what the judges in the 19th century were doing, were treating juries as sampling mechanisms. And actually, juries are pretty good as sampling mechanisms. But as you know, what you need in any kind of sampling mechanism is a way to control outliers. So they were also doing that. So the median of verdicts, if what we mean by pain and suffering, say, or loss of companionship, say, or whatever, is what a random selection of the population, truly randomized, would say, or at least the median of those samples, that's fine. Juries act in that way very effectively. But what you then need are mechanisms to ensure that's happening, and the 19th century judges did it. That's the interesting point. Now, and you also now see why caps, to my eyes, are weird. caps just cut off the upper bound. They don't deal with the lower bound. They don't deal with the cases where the cases should be higher, the verdicts should be higher, and they don't really deal with what the problem is. What the problem is reliability. It's not aberration, it's reliability. So I was supposed to spend 10 minutes talking about the policy implications of this. I have no idea what they are. I'm not a tort scholar. But they do have implications for constitutional adjudication. As I said previously, either there is a fact of the matter or there isn't. If there's not, it's pretty plain the State Farm versus Campbell regime needs to be imposed here. If there is a fact of the matter, you have to identify it and say what it is in a reliable fashion. In other words, it's just false that juries have, well, it isn't false that they have always had this discretion, and it ought to be replaced with some regime that actually focuses on a fact of the matter and gets it right. Thank you very much.
Thank goodness it's not my name that had just come up. So I'm Kathy Sharkey from Columbia Law School, and I'm going to talk about some results of some joint empirical work that I've done with Jonathan Click at Florida State, and also I've summarized in a book chapter that I've handed out called Crossing the Punitive Compensatory Divide. So why don't I just explain the title? The punitive compensatory divide, in my mind, has to do with the rigid doctrinal categories that we in the torts realm as professors talk a lot about compensatory damages being functionally distinct from punitive damages, right? The idea is that compensatory damages, I might just sum up by saying there's a fact, but I want to do it slightly differently. Compensatory damages designed to redress concrete losses suffered by the plaintiff, and then allegedly punitive damages designed to punish and to deter conduct of the defendant. So you could look at it either as a functional difference in the purpose of the award or even in the whole framework. One, for compensatory damages, you focus on the plaintiff and the losses to him or her. And then two, punitive damages, you'd switch focus and focus on the defendant and the conduct of the defendant. Just wanted to be sure. I had a student once tell me that without PowerPoint, that what a professor did is put up his or her name and the title of the day's lecture, and then everyone with their laptops was invited to put up posting running commentary, agree, disagree with various things that the professor was saying, which I'm happy that they haven't employed here. So. In any event, this rigid doctrinal categories, my argument is, not only affects the way we teach tort law, but has important policy ramifications. Namely, a lot of these policy reforms, and the one I'm going to talk about today, caps on punitive damages, are obviously structured implicitly with the idea that you could restrict, right, or confine one category of damages. So if you impose punitive damages caps, then you will lower the amount in punitive damages, but there will be no effect on compensatory damages. So you will lower total awards, and implicitly that seems to be the intended purpose for enacting such a policy reform. The reality, I think, is that there's no clear demarcation, either particularly in practice in our litigation system, between compensation and punishment, that there's a blurred distinction. It comes up, nonetheless, that a lot of our legal policies, like the fact-law distinction with respect to de novo review for punitive damages and not, at least at the moment, for pain and suffering non-economic, are built on that, and a lot of these policy reforms follow. So what I posit is what I call the crossover or substitution hypothesis, which is that as states, it's simple to define, as states enact caps on punitive damages, you might see a corresponding increase in the non-economic compensatory damages, particularly the pain and suffering component. So this crossover or substitution hypothesis, it's sort of interesting because at the one hand, it's radical. It's radical in that it challenges this doctrinal rigidity. It also challenges, right, the sense of numerous legislatures that would enact selective caps. At the same time, it's not radical because it seems to be part of prevailing common wisdom. At least this is the case that many courts have shown judicial recognition of this fact. So, for example, over 2 decades ago, there's a case from the Wisconsin Supreme Court where a judge said that if the punitive damages are not allowed, juries will give vent to their desire to punish the wrongdoer under the guise of increasing the compensatory damages, particularly those for pain and suffering. Secondly, there are numerous cases that I've gathered together. Again, this is sort of what I'd call the anecdotal evidence, where courts, particularly appellate courts, where they're looking at instances where, for example, punitive damages have been awarded against an entity like a municipality, who is immune from punitive damages, so a jury verdict has gone inappropriately, giving an award of punitive damages on appeal, instead of just striking that portion of the award, they will remand and ask the jury to redetermine the compensatory damages on the theory that the jury thought maybe that they were covering part of their basis in the punitive damages, seemingly to me being a judicial recognition of a kind of compensatory component of punitive damages. And likewise, the converse happened. So namely, if the jury was unrightly or unduly precluded from awarding punitive damages, right, instead of just remanding the case to have the jury redo the punitive damages, they'll open up the compensatory and punitives on the idea that there might be a punitive component that had been added into the original compensatory award. So to me, this is judicial recognition. Also, the Supreme Court, in not its most recent, but its, I guess, penultimate at this point, punitive damages case, State Farm, has what I think is a powerful insight that while a major role of punitive damages is to condemn conduct leading to outrage and humiliation, that compensatory damages may already contain what they describe as this punitive element. So it seems to me that courts have recognized that there is a kind of blurred distinction, at least in practice, between compensatory and punitive damages. And if that's right, I think that should lead us to really challenge these doctrinal categories. Secondly, academic commentators for a long time have recognized this. Victor Schwartz, who we've heard from earlier, wrote a law review article where his premise was that plaintiffs' attorneys were, quote, pouring new wine of punishment evidence once used to obtain punitive damages into old bottles of pain and suffering awards. And likewise, there's a recognition, a lot of jury consultants who've been asked to explain recently why it seems like punitive awards have been going down in the annual survey that things like the National Law Journal put out. Jury consultants have been quoted as saying similarly that it appears that plaintiffs' attorneys have reacted against caps in terms of pouring energies into getting larger pain and suffering awards. So all of this led me to wonder that given that this is an area where there's a lot of received wisdom. There hadn't been a lot of empirical study. So I say that sort of cautiously because it turns out there was a huge body of empirical studies that are different from the ones that you've heard about up until this point, which is namely there were a lot of experimental mock jury studies done on this question, a huge wealth of behavioral psychologists who had focused a lot of attention on gathering together mock jury groups and doing things like not allowing them to give punitive damages, one group, and convening a separate group of mock jurors and allowing them to give punitive damages and seeing what the effect would be. And a lot of those studies came up with the idea that if you preclude the jury or the jurors from one avenue, namely they are precluded from awarding punitive damages, they would inflate the compensatory awards, the non-economic compensatory awards. Some of the others were more equivocal and found that if you preclude the jury altogether from doing so, you get that effect, but if you only cap the punitive damages, either that effect goes away or it's much less. What's interesting to me is obviously to do this in a mock jury setting, setting aside sort of whether mock jury settings are replicable in the real world, you have to disclose to the jury the prevailing rules. In almost every jurisdiction, save two, I think, that I've found, jurors are precluded from hearing about the caps in their reigning jurisdiction. Now, these behavioral psychologists don't worry too much about that. They say, you know, most people read the newspaper, they know about tort reform, all it takes is one juror knowing these things. I've never seen that actually empirically tested, and I know it's difficult to ask jurors about their knowledge of tort reform, but that's actually one area that I would identify for further research that would be really interesting to know something about. So what Jonathan Click and I decided to do, and actually I started with a precursor of sort of what I'd call less sophisticated econometric studies, and then Jonathan came on as a co-author, and we've done some more sophisticated econometric studies, all of which have confirmed the basic result using what I think is a particularly interesting data set. Now, we've heard a lot today about limitations of data sets, so there are going to be limitations to the one I'm going to tell you about. But if you were, this is what I'll say, is if you're interested in trial and bench verdict data, right? So a lot of people aren't interested in that at all because it leaves out all the settlement data, et cetera. But if you're interested in that, then I would put forward that the data set that the National Center for State Courts has collected, which has been done on a randomized basis. They've done it across the U.S. They've surveyed 46 of the largest 75 jurisdictions, and they've done so through county-based courthouses. So it's county-level data that you can then aggregate up to the state level. Of these 46 counties, it involves 22 states. states. So if you're interested in doing state-by-state variation, you could use this data set. And what's also very good about it is they do it over time in pretty much the same way. So they did it in 1992, 1996, 2001, and the next iteration should be out soon, the 2006. So what you can do is you can test what I wanted to do with this data. Since it involved 22 states, it was quite convenient that of those 22, 11 were non-cap. In other words, no punitive damages caps in those states, and the other half had caps either throughout the period or half of those, about 6 of those states enacted caps during the period, is exploit using some econometric techniques, right, the difference between what happens when you impose punitive damages, whether you do see this inflation of the compensatory damages. So there's not a lot of time to go through all of our various specifications, but the bottom line is that we actually find, using a whole lot of various controls in this study, a pretty significant, or both statistically significant and a large in terms of substantial impact of an effect. In fact, so much so that we're worried by it, right? You will often hear empiricists worried that the magnitudes of their effects seem too big. But basically, when we look at this, it would come out to somewhere between, looked at in one direction, sort of a 2 to 10 times compensatory damages effect would be the imposition of punitive damages cap. And that actually goes up when we limit it to just the high-end punitive damages awards. So we could talk, if anyone's interested, in some of the reasons why, some of the additional controls that we had to add into that to make sure we weren't picking up spurious kinds of correlations. But I'm pretty much convinced, I guess because I started with a pretty simple double difference model several years ago, and with John's addition to the team in numerous different specifications and robustness checks, we still have this impact, that it does exist. The interesting question here would, of course, be what are either the explanations for this, number one, and then number two, the policy implications. Now, I'm not going to claim that I'm running out of time, so we're not going to talk about the policy implications. I know, I understand that. But that's not the reason I've left it till now. Got to get this admonition to follow my manuscript, stick to time. I like this, very rules-based, which is good. In any event, I'm not going to claim that I'm running out of time, which is why I wouldn't talk about policy implications. I actually think that empiricists should be extremely cautious for all of the reasons that you've heard already about limitations in the data set, what we're looking at, specific questions, from jumping from there to radical policy implications. Here, for example, there could be numerous alternative explanations for this kind of crossover effect. You might start with one, contemplating that there's certain types of cases where this blurred distinction between non-economic and punitive damages would be the essence of the legal claim. Take sexual harassment cases, for example, where jurors are told to give both non-economic damages and punitive damages for the exact same humiliation, shame, etc. In those cases, it's hard for me to see why one is a fact and the other is not, for example, or how why we wouldn't just expect this kind of blurring between categories. Number two, you might have manipulation on the part of plaintiffs' attorneys, right, who are sophisticated, and even if jurors aren't aware of the caps that are prevailing, so long as the plaintiff's attorney has sort of a ready and willing body in the jury, and you can contemplate reasons why the jury might have a holistic number for damages, then the plaintiff's attorney can shape his or her case to try to elicit a higher non-economic component. The final alternative explanation, though, and it's one that I think has been too much downplayed in some of the previous empirical work, is huge selection effects. So when caps are passed, right, it really might affect the types of cases that come forward. So I'm not studying here medical malpractice, but since a lot of the previous case studies that we heard about were about that, imagine caps on non-economic damages are passed, and it suddenly makes certain cases that have high economic damages in medical malpractice very lucrative for a plaintiff's attorney, and others that previously would have been lucrative to bring forward are not worth it. So that might entail the elderly or harms to non-working women and the like. So in terms of my concluding sentence, it would be that I think this crossover effect is real. I think that the policy implications could go in radically different directions. One direction would be bolstering the divide between compensatory and punitive damages through things like jury instructions, bifurcation, and the like. I don't tend to think those are going to be particularly effective. The other would be recognizing the inherent fungibility and trying to come to terms with reforms that aren't centered on selective capping of these categories. Thank you.
Not that often I get to please my colleague Ronald and so easy to come with a tie. I'll try to do it more. My last time that I wore this suit and tie was 5 years ago when I was in the job market. My son, who was 6 years old, told me today, "Daddy, you look so cool. So if I can please both my son and you at the same price."
All I can say is your son has very good taste.
All right. So this morning I presented a paper where I showed that once you, what I argued, adequately account for the possibility of a strike down, you get that in fact caps, and there was also another reform, but I want to focus on caps. Caps have a huge impact on average payments. The reduction was in the 50 to 70%. Which might suggest that Victor Schwartz and his friends are doing an effective work. I don't want to say efficient work because I have no view if it's a good idea or a bad idea. I mean, I do have a view, but not based on this paper, whether caps are good or bad, but at least I can suggest that they're doing an effective work, they're achieving what they're trying to do. Well, now I want to try and argue that, in fact, they're not. And here's why. So you saw that, plenty of reforms over the years, and the question is, do tort reform achieve their intended goal of reducing litigation costs and time to settlement? Or, and that's the hypothesis I want to test today, do lawyers reacting to caps, in fact, delay settlements until after reform is struck down? So if I'm a plaintiff lawyer and a client comes to me and said, "Look, this doctor took my wrong leg out," and I might tell him, "Look, there's just the reform was passed. You're not going to get more than $300,000 in pain and suffering damages or in punitive damages." But I hear that it's on its way up to the Supreme Court, and it might get struck down in 2 years. We still have time with statute of limitation. Why don't you wait, and we'll see if it's struck down. If it's struck down, I can get you more. So under this hypothesis, high-value claims will be delayed until after reform is struck down, and low-value claims which are not affected by the caps will be settled immediately. So in fact, what I identified this morning as if there is a huge impact of tort reform on payments is in fact just a selection effect. So I wanted to test this, and well, I think I already said that, I guess, so I can skip. And there are two competing forces here. Caps could decrease total litigation costs and time by increasing the fraction of cases that settle, right? I think you have some intuitive kind of sense that when you have caps, maybe more cases will settle because now plaintiff lawyers don't want to go after the runaway jury anymore because the maximum they can get for pain and suffering damages is $300,000, so they will settle more. But caps can also increase total litigation costs by increasing the time required to resolve lawsuits, which is the effect that I just started my talk with. So there are two different effects that caps might have. One, increasing litigation and time to settlement, litigation costs and time to settlement by incentivizing plaintiff lawyers to wait until after a reform is struck down. Second, because if caps are not struck down, if the expectation that caps will not be struck down, then let's settle now because I cannot get into the jackpot anymore. So I wanted to test, which one of these dominate. I forgot to say this is a joint work with a colleague here in Northwestern, Alvaro Bustos, who is a very good economist, and together we thought about the way to model this. And so we modeled this. And you might think, well, now after I have a model, I'll tell you in a second about this model. Now that I have a model that can, in fact, explain these two effects and how they would come across, and I can generate hypotheses, now I'm probably even more sure than before about my intuition because there is a rational way to justify. Well, frankly, it's the opposite. Now I'm even less sure than before because I know the assumptions we needed to make in order to get this model to generate the predictions that we were interested in. So I'm still hoping we'll be able to get a kind of more robust model that will keep the hypotheses, but will need, I guess, not as strong as assumptions as we make here. Anyway, what is the model? We assume the defendant makes settlement offer S1. It's hard to see there in period 1. It's a 2-period model. Then the plaintiff either accepts the offer and then there's no more dispute, or the plaintiff rejects the offer, and then either he says, I'm rejecting the offer, I'm going to court, I'll see you in courts, I'm suing you, or he says, no, just I'm waiting, give me a better offer. And then the defendant comes back and in period 2 and says, look, here's my other offer. And the plaintiff either accepts the offer or goes to court, and that's it. So that's the model we assume. As you see, it's a simplifying it's not how it really happens in real life, but it's we simplify real life, but we hope and we think that we're kind of capturing the essence of the process. So if you do the math in this model, which I really recommend you doing, what you get is, just to practice your brain, what you get is a few propositions. One of them is about the time to dispute resolution. So how much time does it take to settle? And what those letters mean is NSC is states with non-solid caps, NC is no caps, and SC is solid caps. So what do? We divide caps. So first we have states with no caps. Those are the NCs, no caps. And then the states with caps, there are two types of states with caps. States with solid caps, that is caps that will stay there forever, like California, that has caps for 30 years, over 30 years now. They have been upheld over several constitutional challenges. They're there. And then we have states with non-solid caps, like Ohio or Illinois, states that have been known to strike down caps. Right? So we divide it in this way, and we can talk about how did we decide which caps are solid and which caps are not. That's some limitation of study, but although we are working to make it to improve the paper at this point. So what the model predicts is that states with non-solid caps, remember those where there are high expectations that the caps will be struck down, there the time to settlement will be longer, right? So it's the story that I started with. I'm a plaintiff lawyer. You come to me and I tell you, look, this cap, I think it's not going to stay there. It's a non-solid cap. Why don't we wait and settle later? And there, the time to settlement will be more or longer than states with no caps, and the shorter time will be in states with solid caps. All right? So this is the intuition I started with when I contacted Alvar about this, and the model generates that. And then we also have predictions. We have several propositions, but this next important one is proposition 4 about recoveries. What the model generates is that with respect to load type, it's not clear what caps are going to do. There's reasons why they won't do anything because they're not binding. On the other hand, they may have some effect. I don't want to go into this. With respect to high type I mean severely injured patients. Those are all medical malpractice, if I forgot to say. What the model predicts is that states with no caps will have higher recoveries than states with caps, whether or not they're solid. This is not exactly my intuition. My intuition was always that in non-solid states with non-solid caps, the recoveries will be higher, but this is what the model predicts. Okay, so let's look at the data. So you already know it's National Practitioner Data Bank. I talked about it this morning. Has some limitations. We can talk about it. I know we won't, but we could. And then this is the statistical model. Very straightforward, one-dependent variables, time to settlement. And these are the results. So what do we see here? First, just simple graph, nothing fancy, no regressions. Everyone can do it. You can see that. I'll go to this later. You can see that states with no caps, the average in the data set is 4 years, time to settlement. States with caps, it's like 3.3. But then when you break down states with caps to solid caps versus non-solid caps, you can see that the bang from lower time to settlement comes from solid caps, whereas non-solid caps, in fact, it's even larger than in states without caps. So that fits the story I was trying to sell you. Now I'm just going to show you a table, which means it's some regressions. Doing more sophisticated analysis, basically reaching the same result. So I ran several models here, and again, what you can see is that model 1 is the less sophisticated one, and as you go to your right, it becomes more and more sophisticated. But basically, you can see that solid caps reduce time to settlement between half a year to a year and a half, and whereas non-solid caps, these are all compared to states without caps. and non-solid caps increase time to settlement by roughly 1/3 of a year, again, compared to state without caps. So between them, there could be something like almost 2 years difference between state with solid caps and non-solid caps. So that's the first result. Then I have a similar thing for recoveries, and what you see is basically this is almost significant. It's almost made it. So you can see that indeed high-type plaintiffs, their recoveries are lower in solid cap states, but not in non-solid cap states. So to summarize the results, the prediction of the model was that solid caps decrease time to settlement, whereas non-solid caps increase them. Well, that was the model. What do we find? Solid caps resolve between 0.59 to 1.74 years faster than in states with no caps, and non-solid caps resolve 1/3 of a year more slowly compared to states with no caps. What about recoveries? So the model generated predictions that caps would decrease recoveries of high-type victims. Indeed, high-type victims, the recoveries were 10 to 13% lower, and with respect to low-type, it was in non-solid caps, it was more ambiguous. So what are the implications? Well, there are implications for severely injured plaintiffs. Caps seem to hit plaintiffs with large claims the hardest. I guess everybody already knows that, but this is just another piece of evidence. And these plaintiffs either receive low recoveries, which I think everybody knew that, and maybe what's new here is that if caps are not solid, then those plaintiffs are being hit by not necessarily getting low recoveries, but just getting it 2 years later. And I don't want to talk about that. It's not that important because this federal bill is not going to pass anymore, so we can skip that. And that's it.
Thank you. According to instructions, we're going to have comments in order of the names in the program. And alphabetically, you're toward the end, but you're the first, Albert.
Right. I've actually negotiated with my fellow panelists to go either second or third.
With whom did you forgot? You think your tie allows you to close your consultation with me?
I wasn't going to play the tie card, but John mentioned that my wearing a tie does give me some
John,
latitude.
you went first.
I'm fine. Albert needs to put some PowerPoint up in order to illustrate his talk, so I'm happy to go first. Well, let's see. For Ronan, I guess I don't have too much to say, but I gather that it seems that my work on constitutional litigation leads to this time differential in non-solid caps, and it looks like the plaintiffs in those states are recovering some more money than they would have if the caps were solid. So I want to encourage you to quantify that number because I really want 1/3 of it. Let's see. My primary responses here, I guess I have to look at my notes. For Ron, I think you seem to say, and I think Ronan seemed to say, I think other people seem to say, and I want to say, that I think what people are saying here is that whatever you think, wherever you stand in this debate, if you want to limit award, if you want to decrease the cost of the system, the caps are an incredibly inelegant way to do it, and really just from a legal perspective, not very good. Effective in some of Ronan's work shows, but I think it will be very interesting to segue to the next section of this afternoon's thing, which talks about, takes, to my mind, one of the first more serious looks at what policy alternatives should be. Back to Ron. I'm sitting here, I'm a small town lawyer and not that smart a guy, and I'm looking at a guy who holds a name chair at one of the best law schools in the country. And I know that if I accept his premise, I'm toast. I trust his reasoning to be that good. So I'm going to question his premise. And I think what I see here is your argument, Ron, is built around the idea that juries are deciding a fact. And I think that's imposing a category that doesn't need to be imposed. I think historically and constitutionally, what juries do is decide damages. And they also decide the issue of negligence, still in most states. Do you want to call that finding fact? Do you want to call it finding law? You can call it that, but the case law, the history, is clear that we created the jury to perform a function, and that function was finding liability and finding damages. So when I argue this constitutionally, I talk about it functionally. I don't need to distill those, to impose those terms that I think came later in the development of the law on this in order to find what it was. And I want to talk briefly, I'll start with Bushell's case, which I think is a key point here. Bushell, anybody here associated with the University of Pennsylvania? Because Bushell's case started with William Penn. And Penn was a Quaker rabble-rouser in the streets of London, and he got arrested for inciting a riot when he was proselytizing. He was brought before a jury. The jury was instructed by the judge to convict him. The jury didn't. The jury was jailed for the crime of attaint. Attaint was the crime of a jury not obeying the instruction of the judge to find somebody guilty. Attaint was originally punishable by total forfeiture. Total forfeiture wasn't engaged at the time of Bushell's case, but Bushell was sitting in jail, got some good, probably plaintiff's contingency fee lawyers, to go argue before the court. And the court abolished the crime of attaint. And Bushell's case is really the birth of judicial independence, because the judges at that time were in control of the crown. And this is the judges saying that we are independent of you, and saying the juries are independent of us. We're both part, but establishing a key point here, and building on, implementing what is, I think, legitimately another idea of the Enlightenment, the idea of separation of powers. This is the creation of a judicial branch and of an independent judiciary. And that's the role that juries played in it. And that's the role that came to this country. And they performed that function. And now, Ron, your argument talks about the textual reference in the Seventh Amendment to the Reexamination Clause to finding facts. Well, all of the state constitutions that had jury trial rights prior to the implementation of the federal constitution and subsequent to, they don't use the word fact. They talk about you have an inviolate right to jury trial. They talk about the function, not the dichotomy. And they came to this country, and Marshall alluded this morning to the first treatise on torts, Francis Hilliard. Hilliard, in that treatise, talks about what I think the origin of personal injury law is. He talks about you have a property right in your body. Again, another big Enlightenment idea of property and how it's done. And injuries to the body are injuries to property. Now, at the end of your paper, you talk about you don't allow the transfer of one person's property to another. And I'd assert that what a jury does is first assign where the property right exists. Because when a person is injured, a property right is affected. And the question is whether somebody else is responsible for that property right, first on the liability question. And the second question is, what is the value of that right? And we assign the jury the function of finding it. Now, why do we do that? We have powerful policy reasons why we don't allow trade in bodily injury. Battery law, tort law in general. We don't have a market in bodily injury. We don't have a market in body parts. The jury is the mechanism we created to substitute for market evaluation of the value of those claims. It performs that function. And it performs that function in part because of a democratic value about the participation of average citizens in that kind of decision making. There are explicit references throughout the 19th century to jurors performing that function because we did not trust legislators to perform them. That is a legitimate piece of the constitutional history. So the suggestion that legislators should perform the function, one, has been rejected, and two, represents also a separation of powers problem in our existing constitutional paradigms. So I think, that's my take on where the jury is and why it is so important to keep the jury in that position, because the suggestion here otherwise is part of what I take to be one of the primary thrusts of most modern tort reform. And that is a move to put decision-making power, take decision-making power away from ordinary citizens and put it into the hands of elites. And in this case, I call legislators elites. And in general, this thrust of the legislature knows all. No, the legislature, we had that debate and we rejected it. If we want to have that debate as a matter of constitutional questions, we can have it. But we had it and we rejected it. It was resolved. You invoked the Mathews V Eldridge paradigm on the due process analysis. Now, on your first point of it, one of the things to point out, I think, is that Mathews V Eldridge is about your relationship to the state, not your relationship to other private parties. And to invoke your analysis in that way, I think you have to acknowledge that a court adjusting the disputes of private parties is performing state action for constitutional purposes. It's an old knotty problem in constitutional law. I think it has you defending Shelley versus Kramer, which I happen to do. I would agree with that. But I would note that that puts me in a very distinct minority. But the other problem, I think, is that when you invoke the Mathews v. Eldridge analysis, the highest process known under the Mathews v. Eldridge analysis is a jury trial. It's the process we insist on when we take liberty. It's the only process we permit for the death penalty. It is the paradigm above all others.
Ron, I think you could reply now instead of waiting. Since, yes, please do. I'll give you 3.5, maybe 4 minutes. You want to come here?
Okay. I have the sense this won't be the only attack, the stings of which I will feel this afternoon. I'm happy to come up to the podium as often as I possibly can with the typical ego of a law professor.
David, take that off as 3.5 minutes.
I'm not no, that clever introduction gives me another 10 seconds. I'm not attacking or defending anything. I'm an analyst. I have no dog in this fight. But what interests me is propositions with truth value. End of story. So when you talk about, I have to make this argument or that, I have to make that argument, I just shrug my shoulders and say, no, I'm going to present the data, including the analytical implications of what I see, and you can make of it what you will. Having said that, there are some things I would disagree with. Bushell's case was a criminal case. It wasn't a civil case. Bushell was charged with breach of the peace, I guess. And we're not talking about criminal cases and the role of the jury trial in inhibiting governmental abuse. We're talking about civil cases, and the histories are really quite different. The history, even in the criminal area, which is one of my areas, as you may know, isn't what it typically is portrayed to be. It's typically portrayed the juries had control over law and the facts. That's just false. The most recent research is quite clear. There are a few colonies in which that is true, but virtually none. Having said that, the point I'm making is, look, there are consequences to tying rights and obligations to facts. You can disregard those consequences if you like, But if you don't want to disregard them, then you have certain things you have to do, like identify what the fact of the matter is and find it in a reliable fashion. Maybe the jury is the mechanism by which this is done, but it's really, really weird that in one jury, in one courtroom on one day, that they can assign $10 a day as the value of loss of companionship, but in some other courtroom, in a highly analogous case, a different jury can assign $1,000 or $1 million a day as the loss. Now, I don't see how that can be defended in any kind of rational way just by this rhetoric of juries. More importantly, what I just demonstrated is the rhetoric is wrong. Now, maybe the control mechanisms were not legislatures, or maybe the control mechanisms were not the normal process in which we think about the due process clause, but they were the judges. The judges are part of the state. The judges were rigorously forcing jury decisions to means. You can disregard that history and think it has no consequences. That's up to you, but that's a fact. And the last point I would make is that I don't invoke the due process methodology of Mathews versus Eldridge. I discuss the due process implications of the Mathews case as well as about 20 other cases. And I discuss the literature that deals with all these issues, and what we point out is that every single argument made in the due process literature and cases, with one possible exception, that is that justice must appear to do justice, reduces to factual accuracy. Why do I make that point? Not because I care in terms of my own individual views, it's because it demonstrates something about our history. The history of the due process clause is one about overriding concern about factual accuracy. Why? Because if you don't tie rights and obligations to factual findings that can be reliably determined, you have arbitrary and capricious government.
Thank you. Albert, was your bargain that you go third or second?
We didn't get that far, actually, so I'd be happy to go now, or would you like to?
Go ahead.
Okay, great. Well, in light of John's excellent and extensive comments on Ron's paper, I'm going to limit my discussion to Ronan's work and to Kathy's work. So Ronen actually is doing a lot of really interesting work on damage caps. I actually did a little bit of work when I started out, and I never went nearly as in-depth as what Ronen did. I wrote a paper looking at damage caps in Alabama, again, just one particular state, and I looked at its effect on the awards, but I didn't even think at the time to look at its effect on the duration of litigation, which I think is, if you talk to practicing attorneys, I mean, time is money, and that's something that is really important, and I think I overlooked that when I started out. Excuse me. And since that time, I've looked at a couple of other types of reform, one being offer of judgment rules, and the other ones being screening panels or mandatory arbitration. In the case of the mandatory arbitration, I would have thought that, so the way that this worked is there is, in Nevada, if you want to litigate a case, if you want to sue your doctor, you have to first go through a screening panel as a first step. And you still preserve the right to go to trial, but I think my expectation when I started looking at this was that it would actually decrease the duration, because you could basically resolve things sooner. And what I found was that it didn't actually have that much of an effect, certainly not a statistically significant effect on the duration of litigation. What it did have was a statistically significant effect on the resources that it drew upon the courts. And so, from a backlog perspective of kind of courts, it's a very effective means. But in terms of how it affects the litigants, it's less clear. And so when I started looking at these judgment rules, I was similarly agnostic as to what would really happen. And in this case, we found, I think similar to your study, that when you had these changes in the rules, the duration of litigation went down. And I think one thing that would be really interesting in your research, I think to be fair, I think it goes outside the question you're trying to answer here, but something that I was thinking about is if you could try to think about the mechanisms for why this is happening, why there is this shortage in the duration. Now, you could say that it could be right before and after the passage of the law, there's some anticipation that there might be some regime change. And I think that's interesting in itself because it questions the whole endogeneity, exogeneity of kind of the changes in the laws in terms of analysis. But kind of going forward, is there any reason to believe that damage caps or offer judgment rules should lead to shorter duration? And if it does, why is that happening? So in the case of judgment rules, I didn't really explore the theoretical implications, but one possibility, I was talking with Eric Talley about this, is that there might be some type of kind of mutually assured destruction that's going on. When you have a rule that is symmetric in its form, and if you have kind of equal litigants, you can imagine that you can have shorter duration because basically it gives as Eric says, it gives parties an incentive to kind of talk turkey faster. And the sooner you kind of start talking seriously, the sooner you reach a resolution. Now, we didn't really, I saw him in California, and so, we kind of sat on this project, but I think it's really worth exploring the mechanisms by which you think the shorter duration is taking place. Now, with respect to Kathy's paper, I thought it was excellent, and I don't really do much research on punitive damages, but I think this, as I said, is fascinating. I had all these slides, and which is the whole reason why I negotiated to go second, but I work on a Mac, and so it didn't, anyway, it didn't convert, and so, had I brought finger puppets or something, I could have shown what the slides were trying to do.
What you mean is that the Microsoft products here were inadequate to the...
Well, there's inadequacy somewhere, right? We don't need to point fingers. But I think in terms of Kathy's research, I think she highlights, I mean, this is just one small part of her paper, but she highlights the kind of the next interesting step of research, which is kind of opening up the black box to observe litigation. I mean, usually when you get data on any type of litigation, I've looked at medical malpractice litigation, for example, in the past, and we've had kind of very concrete outcome measures. When did the case file? When did it resolve? Did it go to trial? And how much were the attorney's fees? And how much was the damage award? And I think any way in which you can kind of delve deeper and to see, well, how, I mean, conceptually it makes a lot of sense, but if you can try to get a better sense of how the compensatory and the punitive are all kind of flowing from one direction to the other, I think it's fascinating. I think the challenge, and Kathy, you may have already figured out a way to resolve this, given that the vast majority of cases settle, it's really hard to unpack that, because typically they don't say, all right, this is how much was for economic, non-economic, and this is what we would have had in punitive had we carried that one step further. But I do think that at least you can try to look at some changes in law to see if there's some, at least from a program evaluation perspective, whether that changes. But anyway, I think that this is incredibly fascinating and important work. The last thing I just wanted to close, and it was kind of the whole purpose of having these slides, I think that I kind of wish that the Supreme Court had thought a little bit more about what Kathy was talking about. Now, I'm not sure how far they could have pushed this point doctrinally, but for those of you who look at the recent Supreme Court case law, traditionally the Supreme Court's not all that interested in torts, I think, but they are really interested in punitive damages. And if you look at Gore and State Farm, and most recently the Phillips Moore case, they're really concerned about these high awards. And I think that I'm particularly troubled by that because the Supreme Court's not supposed to be a court of justice. And certainly there are going to be some cases where you're going to have some really high punitive awards relative to compensatory. And I'm not sure that that necessarily in itself warrants the court's attention. The graph I was going to show you, just to kind of, if you can kind of visualize this, is I had on the x-axis kind of the compensatory. I had all the state court appeals cases that involve punitive awards. And so on the x-axis, I just had compensatory awards, and on the y-axis, I had the ratio of the punitive to compensatory. And so if you were to just kind of have a scatter plot, it basically had this downward trend. So as the compensatory awards got higher and higher, the ratio of the punitive to compensatory became lower. And that kind of comports with our own intuition. There's this case that I teach in torts where you have this landowner, and this moving company wants to go across it. And they say, can we go across your land because it'll save us miles of driving? And he says, no, get off my property. And they proceed to go across his property anyway. And there's no damage really to speak of. It obviously offends his sensibilities, and he sues. And the court awards $1 in nominal compensatory damages. I mean, it's trivial, but awards $100,000 in punitive. And well, you may look at that and say that's outrageous, but on the other hand, from a property perspective, you might be able to justify and think, well, this is a large moving company. Maybe this is the only way that you can kind of sanction this kind of behavior in the future. And so if that's the case where it's on the far left side of the axis, really, really low compensatory, and then when it's really low compensatory, it makes sense to have high punitive. But as you move further along, it starts declining. And so I had another scatter plot that had basically different colors, one for whether the punitives were ruled constitutional or unconstitutional. And so before Gore, it just kind of looks a little bit like a hodgepodge. I mean, the ones that are ruled constitutional are a little bit lower than the ones that are unconstitutional, but it's still a little bit intermixed. And then after Gore, it still kind of looks the same. And after State Farm, it still kind of looks the same. And And so, much to my surprise, when the court decided Philip Morris, I actually think that I didn't think it was possible for them to say anything more about the issue of punitive damages, but they did, and actually, in my estimation, I think that they managed to introduce a lot of confusion, because in this case, they talk about how juries are supposed to decide how to punish a defendant, and should they punish defendants who aren't before them. And so anyway, in closing, I think that it would be really fascinating if the court could try to think about some of the points that Kathy talks about and the kind of the fungibility of compensatory and punitive damages. Thank you.
Thanks, Al. Richard?
Thank you. Although I have been accused of inflicting death by PowerPoint, I am going to take the liberty of putting up a PowerPoint presentation.
Here's the mic, please.
Putting up a PowerPoint presentation, because I did want to respond to the role of the commentator in the broadest possible notion in terms of commenting on this, the whole question that's before the panel, the RCAP's effective as a form of legal reform. Thank you. But before I do, let me make some specific comments about some of the discussion that we've heard today. I agree that this whole issue, in the broadest possible issue, that this determination of facts in our legal system is obviously a very problematic one. I mean, even starting at the highest levels. And again, John wanted some sympathy because he was just a little old country constitutional lawyer. I'm a constitutional scholar. I'm not even a lawyer, so I hope you'll be kind in your remarks. But I think we've all been shocked about not juries' inability specifically, but our legal system's inability specifically to gather the facts in life and death cases. In other words, I think we all have been shocked by the error rate in capital cases. And if we have a very high error rate in capital cases, I think we all need to be humble about our current system's ability, our adversarial system's ability to gather truth. Although I realize that there's a tremendous debate on the role of caps in terms of the equity that it imposes, and again, coming back to this argument of caps as a fact, as imposing a set of facts or a view of facts as opposed to juries, there are many variations of equity. I think one of the things that caps do in something as by definition intangible as non-economic damages is that they impose horizontal equity. It's rather strange to me that in our current system, where there are no guidelines for non-economic damages, that in fact we have the perverse effect of actually punishing in the form of awarding lower non-economic damages. Precisely those individuals who show greater resilience, greater recurrence, greater resilience, greater strength, greater stoicism, have greater internal resources. It's hard to see why they should receive less for an injury than someone who recovers less well. I believe that Professor Sharkey's distinction about punitive versus non-economic damages is absolutely true. I think one needs only to look at the way the media covers this, and I think if you look at no matter what the periodical from the New York Times on down, the conflation of non-economic and punitive damages is virtually 100%. When you look at the way juries even speak about this, when you add in the notion of exemplary damages, and it's a little bit unclear to me how you're trying to fit in exemplary damages into either non-economic or punitive damages, virtually all jurors will talk about what they have done for exemplary damages. We wanted to send a lesson if it prevents one death. So I think that this is a problem that bedevils our entire legal system in terms of the predictable unpredictability of outcome assessment. I think Professor Avraham's study of the effect of caps in introducing the notion of the uncertainty of the legal environments in the effectiveness of caps is a very important one, and I want to comment about that specifically. I think that when we're trying to discuss the effect of caps in terms of what we should expect and what is the inherent value in a cap, I think it is in fact important to do it in an environment in which the cap has a reality. to say that we're going to see whether caps work and we're going to compare caps that actually are effective, such as in California where they've been adjudicated, or in Texas where there was a contemporaneous constitutional amendment which virtually made certain that the 2003 caps would be enforced from day one. To say that we're going to assess the effect of caps and we're going to lump together states that have placebo caps, sham caps, or ineffective caps and compare those to states with firm caps is a mistake if we're really trying to look at the effects of caps themselves. So let me, in the time that's left to me, let me talk somewhat about the experience in California. The Doctors Company is a physician-owned medical malpractice insurer. It's a mutual insurer. It's 30 years old, and we were founded by physicians who helped create the California reforms in MICRA. And I also want to talk a little bit about why actually this debate is important. You're familiar with the provisions of MICRA in general, and the one for this panel that's most important, I think, is the $250,000 non-economic damages cap. The thing that makes this cap so important, for one, as an exemplar for other legislation around the country, is that there are no exceptions to this cap. And I'll give you examples of states that have enacted caps that have exceptions that, quite unsurprisingly, have proved to be ineffective. I can't help but to throw in this point when we argue the pragmatic issues around tort reform. The $250,000, is it reasonable today? This figure comes from 1976. Is to point out that the federal compensation fund that was set up for the victims of 9/11, in other words, the deepest pocket in the history of deep pockets, in fact, the deepest pocket in the history of history, awarding or indemnifying a limited group of plaintiffs. In other words, there are 3,000 some odd families that are affected, so it's a limited quantifiable class, was not able to undertake that publicly demanded task without imposing it the same $250,000 cap on non-economic damages. So I think that it's a figure that has worked exceptionally well. MICRA also uses collateral source, periodic payments, and attorneys' contingency fees. One of the questions in looking at caps, well, do they work? Well, that's one of the questions of the panel. Are they effective? Here's data from California. This is Doctors Company rates for all specialists. If you correct for inflation, something that is wrongly applied to most of the tort literature when it's trying to look at insurance reform. If you correct inflation, then I can show you that rates in California have actually decreased 40% since the advent of MICRA. It's been very powerful. If you don't correct for inflation, then I can tell you, I think, a more impressive fact, that for the last 30 years, rates in California have increased by less than 3% a year. One of the things that bedevils studies of the tort system is when people purport to show that there is not a claims crisis and they reduce the effect, or they index the cost of claims to medical inflation. Medical inflation is actually a very small component of medical malpractice costs. There's no reason at all to index claims to medical malpractice inflation. After all, if you correct the cost of claims for the cost of Middle Eastern war, claims can be shown to go down. It's not rocket science why MICRA works. It decreases the number of outlier verdicts. If these numbers look unimpressive, remember that the difference between $1.93 million claims versus 1.3 is 50%. In other words, California has 50% fewer million-dollar claims than the rest of the country. If you look at states without caps, New York, New Jersey, and until recently Ohio, the number of million-dollar claims is 2 or 3 times that in California. So it's not difficult to see what the effect of MICRA is. Now, the argument is made that caps decrease access to the courts. It isn't true. If you really want to look at the litigation system, and I think you would have to, and particularly if you do it for medical malpractice insurance, I think when you try and look at lawyers per capita and then count number of automobile cases, is a little bit different, because personal injury attorneys don't create a demand for litigation for automobile accidents. They can create a demand for litigation for medical malpractice. If you want an index of how litigious a state is, it's very effectively to look at the number of plaintiffs' attorneys per capita. California is a very litigious state. The U.S. Chamber of Commerce, for better or worse, ranks at 46th out of 50 in terms of the hostility of its legal environment to the interests that are represented in the chamber. Yet, the fact is that despite MICRA for 30 years, the frequency of medical malpractice litigation in the state is 50% higher than the national average. That has not changed. Clearly, these kinds of reforms do not limit access to the courts. When we talk about the impact of caps, we should be able to show that they really are effective, that they really do what they're intended to do, and what they're intended to do is to decrease an unreasonable premium pressure on practicing physicians. If you look at this slide, I won't walk you through it, but if you look at this slide, what you come up with is that the average doctor in the state of California, represented in these 4 specialties, saves $80,000 a year in California versus what their premiums would be in 3 other states without caps with litigious environments, namely Florida, New York, Michigan. So the impact is really quite dramatic. Now, again, this issue of certainty of caps is very important. As I mentioned, in Texas, very profound legal reforms were voted by the legislature in 2002, and in 2003, the voters of the state passed an amendment to the Constitution which virtually guaranteed that the reforms would be enforced from the day that they took effect by the legislature. So there was no uncertainty in whether or not these would take place. And again, you see that where you have no exception caps and you have an environment where the enforcement is going to be quite clear, the results are very dramatic. Since 2003, this was September 2003, so it's really, we're only talking about a very short period of time. Rates in Texas have come down 30%. If you think that's unimpressive, remember the math. If a premium rate doubles from 50 to 100, if the premium rate doubles, it's up 100%. To get it back down to where it was before, it needs to fall only 50%. So already within a very short period of time, rates in Texas have fallen 30%. The number of insurance companies willing to insure doctors in the state of Texas went from 4 to 23. For 3 straight years before these caps were passed, there was a decline in the number of high-risk insurers in Texas. For 3 straight years since the caps are passed, there's been an increase in the number of these high-risk specialists. Now, I think Nevada and Oregon both provide very good examples of what I call sham caps or placebo caps, or the effects of caps. A few years ago, Nevada passed a cap that was widely publicized. It was used in those who would oppose the effect of caps as an example of ineffective tort reform. The cap in Nevada said that the cap is $350,000, non-economic damage cap. So that was the headline. But what was it really? No, it really wasn't $350,000. It was $350,000 times the number of plaintiffs, times the number of causes of action. So if, for example, you were failed to diagnose breast cancer for 6 months and had seen the patient 6 times in that 6th month, you would have 6 times $350,000 at a cap. In other words, there was no cap. And so predictably, it had no effect on rates, it had no effect on the environment. A few years later, Nevada passed a $350,000 cap, no exceptions. Rates have come down, the insurance market has improved, and doctors are able to find coverage. In medicine, we have what's called Koch's postulates. I mean, very briefly, Koch's postulates were a 19th century logic rule that proved very important. How do you prove that a disease is infectious? Well, basically what you do is you show that organisms you show that people or subjects that have the organism have the disease. That's number one. And number two, if you eradicate the organism, you eradicate the disease. Those are Koch's postulates. Now, in essence, we have Koch's postulates in tort reform in the state of Oregon. 1987, the Oregon passed the $500,000 no exception caps on non-economic damages. 1998, the total cost of paid claims in the state of Oregon was $15 million. 1999, the Supreme Court woke up and decided that for the last 12 years, the regime in Oregon had been unconstitutional. The caps were abolished, and the next year, the total amount of paid claims in Oregon was increased by 400% to $16 million. It has gone up continuously since that time. So we know that caps are effective, whether we like them or not. We know that no exceptions caps are effective. Now, all remedies have winners and losers, pluses and minuses, takeaways. So, I mean, again, I think it's important to have a context. How serious is the problem that we're addressing here? There are costs to caps. There are costs to any change in the law. What are we getting on the upside? So, in conclusion, let me point out to you today that there are 700,000 doctors practicing in the United States today, although many of them are not exposed to medical malpractice litigation because they're in a research lab or in the military or perhaps in an academic environment. But there are 700,000 licensed doctors in the United States who face 125,000 malpractice claims today. If we held this conference next week, we'd have to increase that number by another 700. This is a major problem, especially when 75% of these claims are found to be without merit. We don't have to argue frivolous. Let's just say no merit. What's the definition of no merit? It means no payment is made to the plaintiff. Of course, there's cost associated with it, tremendous cost, on the average $25,000 a claim in defense costs, but no payment is made. So we have a situation where the vast majority of America's doctors face malpractice litigation, and the allegation is wrong 75% of the time. I have to ask you, if we had a prosecutor who was wrong 75% of the time, indicted the innocent 75% of the time, or we had a cop who made false arrests 75% of the time, how long would we accept it? I think really not very long. And the final slide, again, just to give you a sense of the scope of this problem. This is frequency by specialty. It's over a 10-year period of time. So you're not looking at an aberration of a year, 10 years worth of data. Look at the bottom line just for example. 50% of the neurosurgeons, all of the neurosurgeons in the United States, have a medical malpractice claim every single year. It means on the average, every single neurosurgeon in the United States has a claim every 2 years. We are not identifying bad doctors with this system. So thank you very much.
Thank you very much. My thanks to all of our panelists and our commentators. What's it? It's 3:30. I'm out of time. Unless you want me to continue.
Quick response by Ronan. It is the Ronan show, after all.
I'll take just 1 minute. Well, I'm not surprised that you can bring anecdotal evidence that the solid reforms are effective. I just want to just three points highlight. One, in California, premiums are regulated, so we have to be able to distinguish between these two effects. Second, Michelle Mello and her co-authors have studies that show that in fact 3/4 of the time the legal system performs well. It's different than 25% winning rate. And my friend, colleague Max, once made a very nice point that, in fact, a good functioning legal system should deter all the lawsuits with merits from arriving to courts, because they should be settled. So in fact, when you look at the cases that do get to court, you should see, and you see a high losing rates, that shows that everything works well, because those that had merits were settled outside of the court system. So these are the consequences.
Thank you very much.
Thank you very much. I think we need to go to our next panel.
Take a break.
5 minutes? It's a place. 10 minutes?
10 minutes.
Okay.